So, are you Mr. Rick? Okay, so please have a seat first. Thank you for coming here today. I'm Wani, and this is my partner, Ain. We are senior counsel at the chambers of Shafawani and Ain, and we are actually specializing in employment liability and torts matter. Before that, here are some water for you. Please make yourself comfortable, Mr. Rick.
We have been made to understand from your call and the memo that this matter has been causing a lot of stress lately. It's okay, Miss Rick. Now that you are here, we are ready to listen to your concerns and guide you through your legal options.
Yes, thank you both. For sure, it's been a frustrating few weeks for me. I really placed a high expectation on you in respect to this matter. The last lawyers I spoke to did not really explain anything clearly. The advice just made me more confused and become more frustrated. Oh God!
We are here to help. Just to let you know, this is the safe space, and today's meeting is just to understand your station. Everything you share today is completely confidential. You will probably understand this matter from the legal perspective before you leave today. And please feel free to walk us through what happened openly from your side.
Well, initially this is regarding one of my drivers, David Wong. On 15 March, he got into a serious accident, crashed our company truck into a female motorcyclist along Jalan Tundrasa. It was bad. And now her legal guardian is asking for 350,000 ringgit in damages for rear interiors.
Oh, I see. We are sorry to hear that, Miss Reed. That sounds very serious. Was David on the scheduled delivery route at that time on the accident?
That's the thing, Miss Anne, Miss Wani. He wasn't. We checked the GPS tracking logs. He went about 7 kilometers off the road. We have questioned him. He said that he was heading to a mobile repair shop to deal with a matter in regards to his own phone. The area had nothing to do with the delivery schedule, and I believe that it is not company business. After all, we did not allow such acts. It's against our company policy. Moreover, I even warned him earlier this year about her reckless driving due to several reports received.
Alright, Mr. Reed. So, he made a personal doctor for a personal errands. And it seems, may I know, do you have a clear policy against that? Perhaps something that is explicitly made known to the employee?
Absolutely. Written and signed. No personal use of company-related vehicles for non-delivery purpose. Plus, he was even on probation for driving issues.
Thank you, Mr. Reed. That information is very useful.
So, let us break this down in simple terms. What we are looking at here is something called vicarious liability. That's when an employer is held responsible for something the employee did, even if the employer was not there.
Yes, to be clear, the law says that an employee can be liable for the actions of their employees, but only if the employees was acting within the scope of their job when the accident happened. This also includes tasks like making deliveries.
Right, but this was not related to work at all.
Yes, calm down, Mr. Reed. This only applies if the employee was doing something related to work at that time. If they were doing something for themselves on their own time, it's a different issue.
So, if David was on a personal errand, that means I should not be liable?
Exactly. That's what strengthened your position here. From what you have shown us, he went far off the road for his personal reasons. It was completely unrelated to work. That makes it more likely that your business will not help responsible. And since you have clear written rules, he was already warned before and was under probations. We can strongly argue that this was entirely his own choice and you did not tolerate or approve this kind of behavior. This put distance between his actions and your responsibility, Mr. Red.
Thank God. That's relief to hear. At least there's a hope. So, does this mean I would not be held liable, right?
We cannot guarantee that, but your case here strongly suggests that liability should fall on David personally, not the company. But because he was driving a company vehicles during working hours, there is a slight risk that a court might still find the action somehow connected to the job. But don't worry, we will do everything in our ability to emphasize that this was not part of his duty and clearly against the company policy.
I see. But if, let's say, worst case, the court still finds us responsible, is there anything I can do? Perhaps to maybe reduce the damages?
Yes, absolutely, Mr. Reed. We still have options. There are defenses we can raise to lower the damages you may have to pay. First, we can argue on the contributory negligence. That means the victim might have partly caused or worsened her own injuries. So, in this situation, Mr. Reed, if the victim, she was not wearing her helmet or she was speeding, we can argue that part of the blame lies with her. This could reduce the compensations amount you need to pay.
Alright, makes sense. I get it. If she did not take care of herself, why on earth should I pay fully, right?
Correct, exactly. Second, we can ask the court to require proof for every cent and damages she's claiming. If she says she lost 19,000 in income, she need to show proper documents and not just say it.
Yes. And third, we will consider mitigations of damages. We can argue if she chose a very expensive treatment when cheaper and equally effective one were available. Plus, maybe if she did not try to find other work once stable, we can argue that she failed to minimize her losses and instead, this is also a way to lower your liability.
That sounds logical. I feel better now. I didn't realize that there were so many layers to this. You know, I just want to make sure the company is not unfairly punished for something we clearly did not allow.
That's why we are here. Mr. Lee, we will handle the legal side so you can focus on your business.
Before we proceed with the next legal step, we would like to suggest exploring your options on how to resolve this matter. You see, not every case has to go to the court.
Yes. And yes, there are alternative ways to resolve dispute. What we call as alternative dispute resolutions. They are usually faster, cheaper, and more private compared to the court proceeding.
That's true. In your case, Mr. Reed, we might consider writing to the claimant lawyer, proposing to either a formal mediations or settlement meeting. We can still argue your legal position firmly, but in a way that avoid unnecessary escalation. Of course, if they refuse, we are still ready to go to the court with a strong defense.
I do like the idea of resolving this quietly. I really don't want media attention or long legal battles. If mediation can help us settle this quickly and fairly, I'm open to it.
That's good to hear. We'll prepare for both routes in our reply to the claimant. We can include the offer to settle this through ADR first. If they agree, it could save everyone time and stress.
Alright. Yes, let's start with ADR. But if it fails, then we fight in court.
Understood? That's a wise option. approach will proceed in that order. Therefore, we will need a few more things from you, Mr. Reed, like the employment record, the policy document, GPS login in more detail, medical bills, and any witness statements you may have to be reviewed as our next step. And also, just to clarify, today's consultation is completely free of charge. And if you decide to continue with us on any further work, it will be 100 ringgit per hour going forward. But don't worry, we will provide a breakdown of estimate cost before starting.
That sounds reasonable.
So great, Mr. Reed. So, just a big reminder, while this case is ongoing, we advise you to avoid any direct communication with the claimant. And also, please do not post about it online or speak to the media. In case anyone contacts you, kindly refer them to us.
And if you hear anything new, especially from your driver or witnesses, do let us know right away. We will keep you updated every step of the way.
Thank you again. This really gave me clarity. I feel like I can breathe again.
Yeah, and that's why we are here. We are for you, and you are not alone in this. We will walk you to the in front, Miss Reed. Take care, and we will keep in touch with you. Alright, Ain. So, based on the consultation, our strategy focuses on showing David Wong was clearly outside the scope of the appointment. That 7 km later to fix his phone, thus, the written policy put us in good position. That's where a solid point.
Yes, and we will rely on the fact that there was explicit company policy against this. But we should be cautious and prepared for the possibility as the court sees the use of the company truck as loosely connected to work.
Agreed. So, our legal research should focus on the threshold for when a personal data becomes a fraud. Example, where deviation was held not within the course of employment, and defenses like contributory negligence, strict proof, and also mitigation of damages.
Also, let's request a full policies report, CCTV or eyewitnesses record if any, income proof, and also all communications with the claimant. We will need to prepare a letter of request to the demand soon. Don't forget to request any medical record from the opposing side and income documentation to challenge the quantum.
Okay. Good plan. I will draft a checklist to follow up email to Mr. Reed once we gather the documents. And make sure we prepare Mr. Reed for the small possibility of any partial liability. But of course, assure him that we will argue the strongest possible defense.
Great. He seems reassured. I think we made him feel supported today.
Yes, and that's the goal and the most important part, Ain. Now, let's get back to work.